Okay, I think we can get started now. Good evening, everyone, and thanks for attending our webinar, The Future of Short-Term Rentals in Your Community. Your moderator for this evening is me, Erich Neher. I'm a marketing manager at FirstService Residential, and I'll help guide our conversation and take questions from our audience. So we're recording this webinar live tonight, and we'll send a follow-up email tomorrow with a link to download this presentation and share it with your fellow board members and residents. So this webinar is presented by FirstService Residential, leaders in property management solutions. FirstService Residential is North America's largest manager of residential communities serving the Greater Toronto Area for over 20 years. We make being a board member a whole lot easier. So our goal is to educate condo boards and homeowners on the legal rights and responsibilities when it comes to short-term rentals. We also want to outline some of the challenges to your on-site staff and offer solutions and support for whatever your board decides is best for your community. So throughout this, we're going to go over some notes before the webinar starts. You should see the GoToWebinar control panel. At any point during the webinar, you can ask a question by clicking the question mark button and typing a question in the field provided. If your audio is enabled and you'd like to speak with our panel directly, please raise your hand by clicking the green button with the hand on it. And we'll do our best to answer all your questions as we go. But we'll also have a Q&A period at the end of each presenter. Additionally, we'll give you the opportunity to participate in some poll questions throughout the webinar. So let's test this out right now with a poll. Do you support short-term rentals in your community? The options are yes or no. Simple question. So go ahead, take part in the poll, click yes or no, and we'll see what the results are. So far, yeah, it's a lot of people are saying no. 86% is sitting at no right now. So let's keep going here. So the breakdown for the evening is going to look something like this. We're going to give a brief overview of the topic and some of the key components of the City of Toronto's new bylaw, which takes effect June 1st, 2018. Then we'll welcome Chris Jaglowitz. He's a lawyer specializing in condo law from the law firm Gardiner, Miller, Arnold, LLP. He'll be followed by Erich Gattoni, the Vice President of Property Services at FirstService Residential. So without further ado, what is a short-term rental? So let's break this down. It's pretty basic. The official City of Toronto definition is essentially that it's a paid rental of a dwelling unit for the purpose of providing sleep accommodations for a period less than 28 days. And this includes bed and breakfast, but it doesn't include hotels or motels. So who are the key players in the short-term rental game? So there's some of the obvious ones: Airbnb, VRBO, or HomeAway. HomeAway is also owned by VRBO. But there are also a lot of listings that you find on Kijiji or Craigslist. So there are lots of options when it comes to either listing your property for rent or searching for short-term rentals. So on the City of Toronto website, they list some of the key rule changes that will take effect on June 1st. And some of the most notable ones are, the rental you put up must be your principal residence. Your entire home can be rented to a maximum of 180 days. Entire home can be rented, but only for 180 days, 180 nights per year. It's difficult to say. And then also you must register with the city at a $50 cost. And companies providing short-term rentals must be licensed at a cost of $5,000 plus a tax of $1 per night booked through the platform. So that's a bit of an overview of the city rentals, the City of Toronto's new bylaws. So let's try another poll right now to our audience. Do you know your community's bylaws when it comes to short-term rentals? Your options are yes, I'm fully informed. Yes, but I have some questions. I don't understand the bylaws. Or what bylaws? So I'll give a couple minutes to answer the poll and take part. Looks like most of you are fully informed. 56%, 59, yeah, 50 to 60% look like they're fully informed. 3% don't, so that's a big number. So hopefully we'll be able to inform you a little bit on how you can deal with this in your community. So to dig a little deeper on the legal side of things, I'd like to welcome Chris Jaglowitz to the conversation. Chris is a lawyer at Gardiner, Miller, Arnold, LLP in Toronto, and they specialize in condo law. Chris, thanks for joining us today.
Excellent. Thanks, Erich. Thanks for having me. And hi, everybody. I hope at the very least to provide a little bit of edutainment here, and especially to the 13% of you who have said, what bylaws? What do you mean? What's going on? So I'm glad to talk a little bit about that. And of course, we're talking a little bit about, Erich's given some insight into the City of Toronto short-term leasing bylaws, but we've also got short-term leasing provisions being rolled out in other municipalities across Ontario. So some of the concepts here that we're going to talk about will deal with everything, with condominiums in every jurisdiction in Ontario. So if we can advance to the next slide here, and we'll just give you a little roadmap of what our talk is going to be. And we're going to start with giving a little bit of context about enforcing condo documents. We'll talk about the Condo Act enforcement provisions. We'll talk a little bit about the City of Toronto bylaw, and of course, some of which will apply to other municipalities also, and then just a few strategies for enforcement. So if we can move on to the next slide then, please. And we'll start with the Condo Act, actually with the condo framework here, and that gives us a little bit of the context. Erich is going to be speaking of, Erich Gattoni is going to be speaking about some of the reasons why it's important. We're putting the cart before the horse a little bit. We're going to talk about what your obligations are and how to enforce provisions, and of course, the fact that many of you are joining us here today. You've already got concerns about short-term leasing for any number of reasons. Erich is going to provide a little bit more insight into that. So as for me, I mean, most of the work I do is counsel boards in terms of understanding their rights and obligations, the powers or the provisions of their particular documents, because each condominium is different, and what obligations they have in each of those scenarios. So we start with, of course, the legal framework that runs condominiums in Ontario, and we start with this Condo Act framework. And of course, at the top of the tree here, and we put these in a very specific order, the Condo Act comes first. The Condo Act is what sets the stage for everything, and the Condo Act trumps everything else. So we start there, and then of course comes the declaration, which is like the constitution of your condo corporation. It is the most important document of your condo corporation. It sets out virtually everything other than the stuff contained in the bylaws and the rules. And the bylaws, of course, typically are the operational documents, and then the rules set out, well, as you can expect, the rules that govern the use of the common elements and the units. And the documents in order, as I said, are the Act, the Declaration, bylaws, and rules. Now, let me tell you what the Condo Act says about leasing and leasing units, and it doesn't say a whole heck of a lot. Basically, it says when an owner leases their unit, they have to give the condo corporation notice within 10 days of that lease and a little bit of information about the lease, and then notify the condo corporation again within 10 days after the lease ends. So that's mostly what the Condo Act says about tenancies specifically. So it doesn't, if someone says, does the Condo Act prohibit short-term leasing? The answer is no. However, the Condo Act also provides that unit owners and occupants and tenants and condo corporations must follow the Condo Act and the declaration and the bylaws and the rules. So then that takes us then to looking at the condo declaration. And because every condo declaration is a little bit different and every condominium is different, the actual provisions in each declaration they can vary very widely. For instance, some condo corporations, a small number, they actually permit short-term leasing. So that's an unexpected thing, but in a small number of condominiums, they're intentionally made for short-term leasing. And then there are many others, most others, that contain provisions saying the use of these units is for single-family use only. And so we'll talk a little bit about that concept in a minute. And also, some condo corporations' declarations may provide no commercial use and contain other types of restrictions as to how condo units may be used there. So those, whenever I'm asked by a board that I haven't worked with before, or I'm not familiar with their documents, and they ask me, Chris, is short-term leasing permitted at our condominium? And of course, my answer is always the same, and that is, it depends on your documents. It depends on what your declaration says and your rules. Now, I've got bylaws up here on this list, and that provides, it typically might set out the rule enforcement mechanisms if your condo corporation was created after 2001 or not, and that will contain certain governance provisions and so forth. So the bylaws in the context of short-term leasing aren't all that terribly helpful or relevant. So we don't have a lot to say about bylaws, but what we do also have to look at are the rules. Now, you might have a condo declaration that doesn't say anything about short-term leasing, but it may be possible, and many condo corporations do pass rules to restrict or limit short-term leasing, or to define what is a short-term lease. Erich mentioned just a second ago that the City of Toronto defines a short-term lease as anything less than 28 days, 28 consecutive days. But it's possible for a condo corporation to enact a rule that defines a short-term lease as something longer or shorter. And one that I see quite frequently is a minimum lease term of a year or 6 months. So it is possible for a condo corporation to create provisions or prohibitions against short-term leasing depending on the length of the term, and for whatever term the board considers to be reasonable. So with that now, let's turn for a second to some of the provisions about what declaration restrictions can provide and how our courts have interpreted those things. First of all, I mentioned single-family use a little bit earlier, and our courts have from these two cases I mentioned, and both of them are Ottawa cases. Surprisingly, there haven't been a large number of short-term leasing cases coming through courts dealing with Toronto condominiums. So far, it's just been in Ottawa. These two cases each stand for the proposition that where the declaration says single-family use, that an individual who runs or a unit owner who runs their unit as a business, as a short-term leasing business on a fairly regular basis or a repeated basis, is a commercial use and is fundamentally inconsistent with the term single-family use. So if you buy a unit, don't put in a long-term tenant and are habitually leasing it out, that would offend the single-family use provision. So that's what these cases tell us. And actually, when we talk about what is a single family, there's one of the cases here talks about that they can't be unrelated people, like for instance college or university students sharing short-term accommodation. They must be related by some family tie, whether by blood or marriage or something like that. So that's what constitutes a family. So these are a couple of the court cases that have come out in the last few years to help define that topic. Now, one thing we didn't really hit here is, okay, so our declaration and rules may contain restrictions on short-term leasing, but what about these new municipal requirements, whether in the City of Toronto or in the County of Simcoe or in the town of Blue Mountain or any place else? And the short answer is that most condo declarations also contain provisions saying that in addition to whatever restrictions or the lack of restrictions are contained in the declaration, units must be used in accordance with municipal zoning requirements. So now we talk about the municipal requirements. And actually, before I get into those, let's advance to the next slide here. And I just want to say a word or two about rules. So we talked here a bit earlier about rules can be used to prevent a hotel, boarding, or lodging house and transient use of the unit. Like when you think about it, the City of Toronto bylaw provision that Erich cited earlier, I mean, it has a pretty broad definition of what constitutes short-term leasing. And so it's obviously important, in order for a condo corporation to establish an effective prohibition against short-term leasing, you have to define exactly what that is. And to say it's like hotel use, boarding use, lodging house, or transient use of a unit. And you can add in, as I said before, a number of days or a minimum number of days that would constitute an acceptable long-term lease, and that anything shorter than that is unacceptable and restricted. And as long as the board is reasonable in establishing that rule, the courts will uphold and assist the board in enforcing those rules. So I'm sorry to have...
Chris,
yeah.
Sorry, can I just jump in here? I think this
Sure.
might be a good time for a poll, because we're kind of touching on some of these issues. And I'm curious if any of our listeners out there if they're aware that there are currently units being used for short-term rentals in their condo. Yes, no, probably, but I don't know for sure. So I'm curious, like, if people are aware of this happening in their units already or in their condo, or if you just think there might be. So yeah, it looks like a lot of people don't know, or say no, definitely. So those are kind of surprising results. I thought more people would know that if that's happening or not already.
It's not. I don't think it's that surprising, for the simple fact that, I mean, when most people pick up a condo declaration or their rules, it's not easy to understand what all of those obligations are. For instance, condo declarations are not easy things to read. I, like most condo managers, probably flip through a few different condo declarations every day, so we can jump to the relevant provisions very quickly. But for most condo directors and owners, you get this declaration when you're about to buy the place, and then you file it away and forget about it. So it is quite easy, and especially where if the board and management have not sort of undertaken an education campaign to say, you know what, folks, we're going to remind you about what the provisions of these documents are. So it does. What typically kicks off that kind of initiative is where the board says, you know what, we're starting to notice some problems, and it's the problems that Erich Gattoni is going to talk about in a little bit. Once you start seeing those problems, then you start asking your managers and lawyers to say, what do our documents say? Is there a restriction? And as I said before, some condo documents actually say short-term leasing is expressly permitted, and sometimes the board and management may be surprised by that if they hadn't looked at it before, and they would only have to look at it if they said, well, we're noticing a problem here. What do our documents say about it? So sometimes we lawyers are the bringers of bad news, but it is pretty easy to tell. Typically in the declarations under the sections dealing with units and the use of the units, it will outline any restrictions there. And of course, as I said before, what municipality you're in will affect that too, because now in the City of Toronto, whether or not your condo declaration or rules restrict short-term leasing, the City of Toronto bylaw will apply once that comes into force this June. So there's that aspect too. Now, let's move into what the municipal bylaws can do, of course. And we said this before, the declarations can set out that, and they typically do, that using units must comply with local zoning bylaws. And that can include any number of restrictions, including hotel-like use or short-term leasing or agricultural use. For instance, if we've got commercial or industrial condo units being used for industrial marijuana grow operations, there may be zoning restrictions against that, amongst other things. So we have to look at that. And it is surprising how many municipalities do not have restrictions on bylaws on short-term leasing at all. So it is important to know that also. So anyhow, let's turn to the Toronto requirements specifically on the next slide. As Erich pointed out here, that actually what the new changes are first, the zoning bylaw will be amended and there will be a brand new chapter in the Toronto Municipal Code, which has like 700 chapters or something like that, to deal expressly with short-term rental. It's intended to be extremely comprehensive. It sets out definitions. It sets out a licensing, registration, and fee regime. And apparently they're going to commit a significant number of resources and city staff to this operation. So it's going to be pretty robust, it looks like here, and of course it will have a registry and an enforcement mechanism. And it also, you would think, this registry might provide condo corporations with the ability to figure out, are any of our unit owners part of this, or is this one unit that we're looking at that we think may be offending our rules or declaration or the municipal bylaw. We can find out whether or not it's actually registered or not. So that's really interesting, and it's a little bit early to tell yet. We haven't seen the amended bylaw or the new chapter of the municipal code yet, but it's coming in, and it's possible, of course, that if someone offends those municipal requirements enough times, that they could lose the right to be registered and to do short-term leasing under that bylaw. So there's a lot to be seen there. And of course, the one thing is, when we're talking about the city or the county or the municipality enforcing any of these aspects, it means that the condo corporation doesn't have to. But I think any condo director that has had interactions with the municipality probably knows that in many cases, the municipality will say, you know what, this is more of a condo issue than a municipal issue. So, we're not going to touch it, and we're going to leave it for the condo to enforce. So that could happen in any given case, depending on the infraction, depending on the municipality, and just depending on the facts. So a lot can happen. And I recognize, of course, I'm not giving a whole lot of really firm answers on how all of this stuff works. And part of the reason, of course, is there are so many variables, including what does your declaration say? What city are you in? Does that city have restrictions? And what is the harm that's coming from the infractions that we're talking about? So that's in a nutshell the City of Toronto regs. Let's move quickly to some pros and cons.
So Chris, could I just step in for a question? We just have a question from our audience. So they want to know if the city's bylaws on short-term rentals will override specific condo bylaws.
Great question. The short answer is that the condo documents can be more restrictive than the city's requirements, but the condo's documents cannot be more permissive. So, for instance, the condo documents, and whether it's a declaration or a rule, can be more restrictive and can say anything shorter than 6 months is a prohibited short-term lease. But the condo documents can't. They could say that the minimum lease is 15 days. And you see that's inconsistent with the city requirements, but the city requirements would prevail in that case. So the condo's requirements cannot be more permissive than the city's requirements. So I hope that helps. That's a really good question, and I appreciate it. Next slide about the pros and the cons. Very good. We got, first of all, I think the city is doing this to achieve a couple of things. First of all, they do get, they are looking at a number of ways in which to sort of knock down the price of housing a little bit here. And I think they figure that if there probably are a lot of investors that purchase condo units as an investment, and if there are restrictions on what type of units can be leased. And of course, the City of Toronto's requirement is, I don't know if we've mentioned this, is that you can only do short-term leasing with your principal residence. So if you've purchased a unit that you're planning to exclusively use for short-term leasing, you've got a problem. The city, that is going to be contrary to what the city is requiring here. So when you think of all those owners who have purchased investment units for that purpose, will no longer be able to do that legally. Does it make sense to continue holding the unit? That's something that time will tell. The next pro, of course, of this requirement is that it is intended to minimize nuisance. Erich will get into this a little bit further. Also, the city intends to use this as a revenue source also. And mind you, we're all glad to see the city get whatever revenue it can get. But I mean, I guess one, and this is more of a con, what will it cost to actually administer this? And will it actually generate the revenue that's needed to pay for the cost of administering it? Like some of these new taxes that are coming out in Ontario and in the city of Toronto, like on vacant properties and on non-resident speculators. I mean, to enforce and to administer those taxes may be more costly than the revenue that they generate. Also, the City of Toronto, in terms of cons now, the City of Toronto regulations and new bylaws, they do nothing to increase awareness. That really comes to the condo corporation. And also, there's no provision for grandfathering. So it's everyone is going to be required to follow those City of Toronto requirements in the City of Toronto. And ultimately, while there might be some opportunity for the city to step in and administer some enforcement, it's entirely possible that they place the onus on condo corporations to monitor and police these aspects. The city could say, listen, we're only doing freehold houses here. We expect condo corporations, if they've got a problem or they got short-term leasing that's unauthorized in their building, that they'll take action accordingly. So that has yet to be seen. How the city actually deals with this is the big unknown variable. So I'm going to move on really quickly here and start wrapping up by giving a few strategies. And first of all, and we've just sort of scratched the surface now tonight with understanding and following your condo documents and educating your owners. It is important for the board to remember that they have an obligation. The condo corporation has an obligation to enforce and take all reasonable steps to enforce its documents. So that's something that's not optional. The board has to be reasonable in doing this, but owners should expect, and they have the right to expect that owners will, or that the board will enforce these rules. And of course, if your condo corporation does not have restrictions on short-term leasing, but you think it's a problem or owners think it's a problem, get their input, hold town hall meetings, take polls, find out what's going on and log the number of complaints and find out, is it a problem that you need to solve? And if so, get your managers and lawyers to provide some ideas for solving it. If you've got restrictions on short-term leasing there, then monitor for infractions. Find a way to do it in an effective, economical, and consistent way. And then on that theme of consistency, we have to enforce consistently. So if you know that there are some owners who are violating the short-term leasing rule or any kind of rule, you have to make sure that the provisions are enforced against everybody equally. Like, for instance, members of the board don't get a pass on this. They can't be treated any differently than anyone else. Everyone should be treated the same. And Erich will have some creative strategies for us afterwards in terms of what else can we do to help manage some of these more difficult situations. So for now, I'll take a stand down and see if there are any questions, or are there any further polls, Erich?
Yeah, so we do have some questions. So don't forget to participate. You can always click the question mark button to ask a question, type it into the field on your panel, or press the hand button to ask a question. And if your audio is enabled, then you can ask the panel directly. So we have a question here. If our declaration prohibits short-term rentals and owners choose not to register after June 1st, who will police it?
Interesting question. In that case, you don't really need to worry about the City of Toronto's requirements. You can enforce your documents on your own. But I guess the question is there, you've really got two violations. First, the individual has violated the condo declaration that says no short-term leasing. And second, that if that individual has not followed the municipal requirements by registering and following those codes, there actually now are two separate violations. Because remember, as I said earlier, the declaration requires owners to use their units in accordance with local zoning bylaws. So that is two different mechanisms. So it's we would enforce that using the Condo Act enforcement process, which right now goes through mediation and arbitration in the case of owners, or if we have permanent tenants or longer term tenants, we go to court. But typically getting the owner's attention will help solve the problem. And actually, the big news story in the last week was a lady her unit had 70 reviews and had been up on Airbnb for months, and she had no idea. Her long-term tenant was apparently not so long-term and was actually carrying on a short-term leasing business. Very interesting stuff. This was just 2 days ago in the papers.
Yeah, I was surprised to read that as well. But I guess it's probably more common than we think, unless you're looking specifically for a property in your building.
Right.
So I have another question. How does the corporation enforce if the owner does not notify the lease as required? Notify of the lease as required.
That's a good one too. And the short fact is, the simple answer is that provision of the Condo Act is more often breached than followed. I'd say if you asked any number of condo boards or any number of condo managers to know how many times owners have, followed the proper procedure and notified the board of the lease and provided the name of the tenant and gave the copy of the declaration, bylaws, and rules to the tenant, it doesn't happen as often as it should. So we have that problem routinely. And typically, if you were to say, well, should we start enforcing that provision? You want to encourage owners to do it, but it's really hard to force them to do it. And in fact, typically when if we know that there's a problem, like for instance, a tenant's dog has bit someone, or a tenant is carrying on a short-term leasing business, we make it our business, and the board makes it theirs to say to the owner, listen, we've got a problem, and you've got to tell us who your tenant is, because we're taking enforcement action against them directly, as well as you, Mr. or Ms. Owner, because you ultimately are going to be responsible for the cost of this unless you secure the compliance right now.
Right. Okay. So we have one other question here. Do you have standard clauses that effectively ban short-term leases? The declaration that this owner's condo has contains a single-family use clause, but no minimum lease term.
Right, and I think just about every condo law firm has their own sort of model short-term leasing rule. So it certainly is something that you can get. And like, for instance, my office, for instance, we do have a model short-term leasing rule, and we say to the board, like, what do you want to set the minimum lease term at, like 6 months or a year or 90 days or what, and do you want to make any tweaks? And frequently they'll buy it, choose the lease term, and just buy it right off the shelf. So it's a relatively simple and inexpensive process. And of course, to pass rules is very simple. It just requires sending it to the owners, and then if the owners don't requisition a meeting within 30 days, the rule becomes effective. Of course, if you haven't done the homework to find out what are your owners' preferences, like for instance, are 75% of your owners doing short-term leasing? In which case, then, if they find out that the board is proposing to pass a rule, they're going to come out, probably vote down the rule, then requisition a meeting, replace the board, and then life will carry on as before. So that's part of the homework the board has to do, is understanding what the wish of the community is.
Right. So another question we have, these are great questions, by the way, so keep them coming. Will condo corporations have access to which owners have registered their units for short-term rentals?
That's a good question. We don't know the answer just yet. I really hope so, because that would be a valuable tool in the corporation enforcing its own rules, and of course to seeing whether or not there's an active municipal violation going on right there. Like if the board is aware that there is a short-term leasing business going on and is not able to determine if there's a registration, then that leaves the board in a difficult spot there. So that's something we'll look into. I don't know the answer to it yet, but I'm hopeful that it is available.
Okay, great. So we'll take care of one more question now, and then we'll move on. We'll address some more of these questions as we go on, and then we'll have another Q&A after Erich speaks at the end of the webinar. So for one more question, for existing condos, do you have to change the declaration, or can you even do that?
It's really hard to amend condo declarations because you typically require the consent of 80% of the owners to do that. And so it's not just 80% of those owners who are there at the meeting, it's 80% of all of the owners. It's hard to do, and especially at large condominiums, it's almost impossible. So there doesn't need to be a change there. And in fact, as long as the declaration doesn't say that short-term leasing is permitted, and it's a small number that do provide that, then it's sufficient for the board just to pass a rule. So typically, we don't need to amend condo declarations to make this work. But of course, there can be weird cases. I don't want to get anyone's hopes up, but typically, in 90% of the cases that I see, there's no need to amend the declaration. So I hope that helps.
Yeah, that's great, Chris. So thank you for joining us. Hopefully you'll stick around for a bit of a Q&A at the end. We might have some more questions come in as we go through this.
Sure.
So yeah,
Thanks.
again, that was, sorry about that. Again, that was Chris Jaglowitz, lawyer at Gardiner, Miller, Arnold, LLP. So thanks for your questions. Keep sending them in and we'll get to them as we move through this. So we've got another poll that we want to launch right now. What is your biggest concern when it comes to short-term rentals in your community? The options are damage, security, maybe noise complaints, or just upsetting the neighbors. So we'll see what our audience is saying right now. Oh, security is a big one. Yeah, I guess there are a lot of security issues around having strangers come in to your property. And that actually is a good segue to our next guest speaker. Erich Gattoni is the Vice President of Property Services at FirstService Residential. He's going to share some insights with regards to how your board and your staff can support your condo board's decision to allow short-term rentals or not. So welcome, Erich. Look at the poll results. It's pretty staggering. Everyone's concerned about security.
Yeah, and I can definitely understand why. So I'd just like to start off by saying good evening to everyone, and thank you all for spending your evening with us, or at least a portion of it today. And Chris, thank you very much for the great technical overview of short-term rentals in our condominiums. So in the for the next few minutes, I'm just going to spend some time discussing how your front desk and cleaning teams can be affected by short-term rentals in your community. And then I will move on to different things that we can try to do to help support managing those short-term rentals in your community as well. So as you can see up right now, we've got about 5 challenges here that your front desk specifically will face. And I'm going to just jump into these right here. So Erich, if you could just go to the next slide, please. So increased traffic. This is going to kind of be an overarching theme for the rest of this section, and the big thing here is it causes a large distraction for the individuals working in your property, especially the ones that are responsible for the safety and security of the residents and everyone in the building, right? And one of the big things to keep in mind is without a short-term rental or just a standard day, you've got your front desk associates, concierge or security, whatever you refer to them in your community. They're dealing with trades coming in and out. They're dealing with deliveries. There's street traffic of people maybe walking into the wrong place and really managing all of that. So being expected to manage the short-term rental side of it as well can cause a lot of challenges for these individuals with respect to serving the community as you would all want them to be doing, and what your condo fees and your maintenance fees are actually going towards them doing. So the next real hot button topic, if Erich, you can just click, is really knowing who's in your community. In some instances, it may be a family vacationing. And I was speaking to Chris earlier, and I just said, a few months ago, I was in France, and I have 2 young kids, and a hotel is just too expensive for us. So we jump into an Airbnb, and we're there, we do our thing, and we leave, which I think is not too bad. I don't think we're that disruptive, other than maybe my kids crying a little bit. But in other instances, you have people trying to get access to the building for multiple reasons. Some would be using the units to run illegitimate businesses. It's interesting, Chris brought up grow ops earlier. I mean, that may be one of many things that people could be using these units for. And the other thing is like throwing events and parties that can be pretty disruptive to the community without any major consequence to them. When you're an owner and you live in that building, or you're renting and you're going to be there for a significant period of time, you're developing relationships with those people around you, and you really don't want to be that person that's disrupting everybody, because it just makes it an uncomfortable space to live in. Whereas if you're just renting it for a weekend or a night, you don't have that consequence that's tied to you. So, Erich, if you could just click on to the next one. So one of the big things, like, and at this point, added distractions is huge, and it kind of goes hand in hand with increased traffic. Your security, there's certain things that your security concierge or front desk staff should be doing, and a lot of it is with regards to access control and maintaining the safety and security of your building and the people in it. So things that they should not be doing is they should not be escorting short-term renters to the units they're renting. And the reason why is there may be something that's going to occur in that front lobby, or there may be people piggybacking in and getting access to your building. And that is why you need your front desk staff at the front desk as often as possible. And if they're showing people to a unit acting as a bellhop or something to that effect, it's just not safe for your community. The other thing that they should not be doing is holding luggage at the front desk. I mean, there's a whole liability issue there as well. I mean, if all of a sudden we have a front desk associate that has a family's luggage behind the desk, and this individual has to go to a different part, or maybe there's a fire alarm, and this individual has to go to the CACF room, all of a sudden those bags are unattended at the desk. And what if in the midst of this fire alarm, someone comes and steals those bags? What happens then? Who's liable? Who's responsible for that? As I said earlier, the front desk associates and cleaning staff, they currently have a full-time job as it is. And they're there to serve the residents in the community. And they don't have time to act as a bellhop or a concierge in a hotel standpoint. So all of these small distractions can really stop them from serving your community. Even if you think about people showing up at a hotel with a car, right? If you have people showing up in a downtown Toronto condo from wherever in North America, and now they've rented a unit there for a week, there's going to be all the access control portions of parking that car. How do you give them access to the parking garage? How do you continue to give them access to the parking garage? These are all things that really take time away from your front desk associates and could actually cause you to maybe have to staff up, which is an additional cost could end up being an additional cost to the condo corporation to maintain the safety and security of the residents if there wasn't a short-term rental in the building. The other interesting thing that we've had occur to our cleaning staff is we've had requests that our cleaners clean the units of the short-term renters, and some of the owners actually thought that this was part of the role of our cleaners, and that's really difficult for our staff, especially when you're trying to deliver a high level of service and you're really trying to support and be good stewards of the condo corporation. So that's something to keep in mind. So Erich, if you could just click on the next slide. At this point, I'm going to kind of talk about both of the next 2 points together, really managing damages and additional complaints. In general, people that are renting in a building, they tend to care less about the building itself. I mean, they're not owners. They may be there on the short-term side, they may be there for a couple days. They may be there renting for a couple of years. And your short-term renters tend to not care as much, tend to care even less than someone renting or leasing for an extended period of time. And I think something that we sometimes lose sight of is that there's specific amenities in your buildings that could, if damaged, if not used with care, could cause a large cost for the condominium corporation, and they would be very difficult to recoup. So if you think about things like your garbage system, if you have a tri-sorter and it is not used properly, you could actually put the wrong type of garbage down the chute, and it could cause damage in the compactor room, which would be very difficult to recuperate because you will not know who is the one that caused this issue. Your hot tubs in your pools. I mean, small children, things can happen in these pools, and you would not know how to deal with this, or well, you'd know how to deal with it, but you would not know how to recoup your costs or who to go after for this, because anyone could be in that pool and then just leave. The other thing too to think about is things like walking through the building, and just the wear and tear that you're going to find. People walking through the building with their luggage. There's a lot of hard shell luggage there. If they're squeezing into an elevator, they could bump it against the elevator mirror, and maybe it cracks the glass. Just increased traffic will cause this in general. So something to be mindful of as well. Bumping these pieces of luggage against the wall. We've seen dents in drywall. We've seen tears in wallpaper. All things to just bear in mind that, I mean, if someone rents a party room and leaves a mess, you can do inspections before and after, and having a deposit for that, you can kind of recoup some of your costs. But with the things I've mentioned, there really is no deposit, or there is no before and after inspections to know where the damage came from. So
Erich, quickly, I just have a quick question, but we got to keep going so we can finish on time. But can you just touch on if your building doesn't have a concierge or an on-site security, how do they manage that?
So that's a really tough one, right? I mean, a lot of that then falls on individuals showing up there. So, I mean, if you're an investor, you may be paying someone you may give someone access to the building, and you may pay them to meet your short-term renter and give them access. There's also lock boxes that can be put throughout the building. The challenge there is, if you have a lockbox with a key or a fob outside a controlled access point, I mean, anybody could really, if they wanted to, access that lockbox. So you could break that lockbox, and now anybody could be getting into your building. Kind of a scary thought, right? I mean, I know there's some buildings that I've seen where there's a commercial parking garage, and they've got like bars mounted to the wall where these lock boxes are connected to. And if you don't have the right camera systems, or you don't have the right ways to really monitor this, anybody, I mean, yes, they're lock boxes, but I mean, they're not like sledgehammer proof, or they're not. There's ways to get into them if you really want to. Does that answer your question, Erich?
Yeah, that's really great. Thank you.
Okay.
So let's keep moving.
Okay, so I mean, like, we can move on to the next point about what can your front desk do, right? And I think this is really a lot of this. This is a really tough one. To be frank with everyone, if there are no bylaws against short-term rentals, there's really not much that can be done. With that said, there's some things that we can attempt to do to support the community. So really, the main point again is working to propose and pass bylaws to limit or eliminate short-term rentals. Security can enforce bylaw infractions, and it would be similar to enforcing a bylaw infraction with regards to parking violations, damages to amenities area, or a mess a pet may leave in the hallway. If we can just keep going here, I'll try to speed up so we have some time for Q&A. One of the things that you can do, especially if you do have bylaws in place, is really understanding what your units look like in the building and spending time to search online on the different short-term rental sites. Because what they're doing now is they're becoming very smart about not putting actual addresses on the advertisements, because for the exact reason of waiting until you've actually purchased the rental for a period of time and then letting people know. So it becomes a little bit more difficult to nail down where these short-term rentals actually are. So if you want to keep going, again, traffic. really working to log, and I'm using air quotes here, log strangers entering your building with a fob or luggage. Sharing this with the property manager so they're aware of what's going on in the building, and this can actually help create a case for changing the bylaws. Like if all of a sudden you see a variety of individuals coming, like families showing up with suitcases and luggage and all of that, like you really need to inform your property manager and work very closely as a team to report and investigate any suspicious occurrences or people. I think that's something you know a lot. You can really tell a lot of times, like when you see people. Sorry, when you're working at a desk for an extended period of time, you get to know the people that are part of the community. And when random strangers come up and are able to just walk by, it's and actually gain access with a fob, it's very evident that they are not typically there at all times. And really just going back to what we've been saying, really working with the on-site team to enforce the bylaws if they exist. And one of the things to just keep in mind here, the challenge with everything that I've talked about in the what can your front desk area do is really these take these individuals away from what they probably should be doing to serve your community. And that's something that we really have to ask. Is it an investment that we're willing to make? You may have to staff up so that you can still serve your community serve your community at the level that you anticipate to do, right? And like just to put in perspective, having an additional front desk person in at your desk for about 12 hours a day, 7 days a week could cost you around $100,000 a year. Is that expense worth having short-term rentals in your community? So anyhow, I had to speed through a little bit of that, but I think we have a little bit of time for a Q&A. So Erich, over to you.
That's great, Erich. Thank you. So we just heard from Erich Gattoni, the Vice President of Property Services at FirstService Residential. So the floor is open right now for questions for either Erich or Chris. So we have one here. I think this is more for Chris. If a single family lives in their unit and rents out on a short-term basis part of their unit, how is this handled in relation to the Condo Act? And how will this be handled in the future with this new city bylaws?
I'm sort of digesting that. That's really neat, because when you think about it, if a single family brings in individuals that are not related to them, you violated the single family use provision, arguably, right? So in that case, that would probably be relatively simple. Like if you brought people in as boarders or things like that, or as short-term guests, that would be a problem. I don't think that violates the City of Toronto provisions, or at least the proposed provisions, because it is possible for individuals in their home to allow to do some short-term leasing in there, so that's not a problem. But it would violate the single-family use provision of the declaration, I would think. I hope that covers it. Right.
Yeah, I think that makes sense. And one other question here for Chris, I believe. Is there a way? Oh no, sorry. Can Airbnb be taxed by the condo corporation?
The condo corporation typically doesn't have these taxing powers. The city does, and the city is, for instance, the City of Toronto is intending to do that. There has been some news stories about agreements struck between the condo corporation and Airbnb, where the condo corporation says, well, we'll permit this, we'll sort of facilitate it, but we got to get a cut of each transaction or so. So that could potentially be done. There's word of it being done, but there are some difficulties that come from it. Like, for instance, could the condo corporation potentially lose its not-for-profit status with the Canada Revenue Agency? And if CRA revokes that status, now you've got the condo corporation in a much more complicated accounting situation. So there's that concern. So it is potentially possible, but it would need to be looked at. But, you know, one thing
sorry, Chris, would that include if there are damages from a short-term renter? Would the condo be able to charge a fee to the owner or to the website that it was rented from?
In that case, I mean, it would be the unit owner who's responsible for it. If they had a guest or a tenant or a tenant's guest or a tenant's guest's visitor's contractor who came and did damage, and the condo corporation could say, yes, we can trace back the source of the damage to someone who came from that particular unit, then yes, it is possible to use the Condo Act to charge back the cost. But you need to have convincing evidence to say who caused the damage.
Right. So that might be tricky.
It could be. And just if I could, one thing, Eric, that jumped out from Erich Gattoni's comments is in terms of monitoring for infractions is to consider there are some services that are out there that where people are monitoring for a fee, of course. They're monitoring Airbnb for infractions related to a particular condominium. So that is another option, as opposed to directors or the condo managers actually scouring these short-term leasing sites for violators. One could hire somebody to do that kind of work, but it is an expense, of course.
Right. Okay, I think that wraps up all our questions. We kind of have to wrap it up now. But I want to thank everyone for all their great questions. I want to thank Chris Jaglowitz from Gardiner, Miller, and Arnold LLP for joining us tonight, and also Erich Gattoni, the Vice President of Property Services at FirstService Residential. We couldn't have done it without any of you guys. We hope everyone found the information helpful to your board and your community. If you have any questions or comments on how we can improve these events, please feel free to follow up with Gene Lewis, our Director of Business Development. So jot down his contact information now, if you don't have it already. But also, please visit us online at www.fsresidential.com and sign up for our mailing list to stay up to date on the latest news and educational events. Plus, get access to resources to help make being a board member a whole lot easier. Thank you, everybody, for attending.